Hello, everyone. My name is Michael Palmieri. I'm the Executive Director of Creative Lab Hawaii. On behalf of Georgia Skinner, Chief Officer of the State of Hawaii DBET Creative Industry Division and the founder of Creative Lab Hawaii, thank you for participating in our Zoom webinar. In a moment, I will introduce our presenter, though I first wanted to share with you a bit about our webinar. Our presentation will last approximately 40 to 45 minutes, which will leave us approximately 10 to 15 minutes for questions from you. If you're interested in asking questions, please do so as the discussion unfolds. We will choose questions during the presentation to answer, and also, as I mentioned earlier, reserve a time at the end of the presentation in order to answer as many as we can based on the allowed time that we have remaining. As a reminder, the series of legal clinics we're presenting this month are for informational purposes only. If you require specific legal advice, we recommend that you consult an attorney. Now to our presenter. Martin Hsia is a partner at Cades, Schutte, LLP. Martin's practice includes advising clients about all aspects of U.S., foreign, and international intellectual property rights, filing and prosecuting U.S. and international patent and trademark applications, and U.S. copyright applications, representing clients, working with the firm's litigation practice group in proceedings before the U.S. federal courts, the U.S. Trademark Trial and Appeal Board, and U.S. Patent Trial and Appeal Board, and filing and prosecuting through an extensive network of foreign correspondents, foreign patent and trademark applications, and prosecuting and defending opposition and cancellation proceedings before the patent and trademark offices of many of the major industrialized countries in the world. Martin has been listed in Best Lawyers in America for 25 years and is also listed in the Martindale-Hubbell Bar Register of Preeminent Lawyers and Who's Who in American Law. He has given addresses on intellectual property matters to groups as diverse as the American Bar Association, Business Law Section, United States Trademark Association, the Chamber of Commerce of Hawaii, the Rotary Club, innovation workshops sponsored by the U.S. Department of Energy, the National Association of Paralegals, a third grade class studying inventions, as well as major colleges and universities and other organizations. Take it away, Martin.
Thank you very much for that kind introduction. The first slide, please. This is about demystifying copyrights. And so what I'm going to try to do is make sure that we're demystifying copyrights for everybody here. I understand that this group is primarily or focused on audiovisual and also sound recording works. So what I'm going to try to do is make a mystical subject more understandable to everybody. This first slide shows you the kinds of rights that you can get with copyright. So that's something really, really important to be aware of. The other thing is that I do have some bit of a personal interest in this. I want everyone who's reviewing this webinar to succeed, because I live in Hawaii and I want to make sure that we diversify our economy away from just tourism. So anyway, continuing on, you'll notice that on the first slide, I have all these scary notices, and by the end of this webinar, you should understand what the notice means. Specifically, any unauthorized copying, adaptation, distribution, display, transmission, communication, or other use is strictly prohibited and will constitute willful infringement, resulting in liability of up to $150,000 plus attorney's fees. At the end of this webinar, you should know what that means. The Chatham House rules apply. You're free to use the information received, but you can't identify, neither the identity or the affiliation of the speaker may be revealed. This does not necessarily reflect my opinions or viewpoints at any other time. It does reflect my viewpoints and opinions as of right now. And what I say does not necessarily reflect the viewpoints and opinions of my law firm or our clients. Next slide, please. Okay, so the first question is, where does copyright law come from? And actually, I should say that this slide is wrong in that the first copyright law actually came from the UK. Statute of Anne is what it was. But in the United States, the first copyright law came from the US Constitution. By the way, in the slides, what I have done is I've taken various things that are mostly available at copyright.gov. So write that down, www.copyright.gov. At the top of the page, you will see drop-down menus, and one of them is about law. And what you want to do is go to the drop-down menu for law, and then you will see the copyright law of the United States there. And copyright law is pretty simple in some senses because there's only one federal law throughout the entire country. There's no state law with respect to copyright, and I'll get through that. So now, the first bullet point, oh, and by the way, when I've copied the text, what you pay attention to is the stuff that I've done, that I've bolded and underlined. The rest of the stuff is not necessarily critically important to read, but you see a whole bunch of text, look at what is bolded and underlined to make it easier to understand what's going on. I did this so that later on, when you're looking at the actual texts, you will understand what the most important parts are. So the first bullet point says, Congress has the power to promote the progress of science, securing for authors the rights to their writings. That's where copyright comes from. The US Constitution, Article 1, Section 8, Clause 8. The copyright law currently in effect is 1976's copyright law, effective January 1, 1978, and modified by various acts, most importantly of which was the March 1, 1989 Berne Convention Implementation Act. The third bullet point points out something very important. All legal or equitable rights that are equivalent to any of the exclusive rights within the scope of copyright are governed exclusively by this title. No person entitled to the rights, there's no person who has any rights under the common law or statutes of any state. Statute is something that the legislature passes. Common law is an interpretation of the statutes or other laws by a judge. And what this means, this third bullet point, is that there's only purely federal copyright law when you're dealing with the subject matter of copyright, which we'll get to in the next slide. Pre-1978 works are not going to be discussed here. Very, very, very important. If you are going to be hiring a copyright attorney, make sure that he or she has gray hair, because somebody who went to law school in the 1990s, 2000s, 2010s may not be familiar with pre-1978 copyright law. Pre-1978 copyright law is still around. It applies to works that were created and published pre-1978. So there are a lot of very important things to be aware of pre-1978 that are very, very different from what happened on January 1, 1978. And in fact, between January 1, 1978 and March 1, 1989, there are large differences as well. Next slide, please. What do copyright laws protect? There's only one thing that you have to remember about what copyright laws protect. Original works of authorship fixed in a tangible medium of expression. It has to be original. A photocopy does not create copyright rights. It has to be a work of authorship. That means it has to be an author, probably a human author. There have been cases relating to computers. There have been cases relating to a monkey, but probably human author, a work of authorship by a human author, fixed in a tangible medium of expression. In other words, it has to be something that is not ephemeral, that is disappearing. So this webinar is being videotaped. Because it's being recorded, it's being fixed in a tangible medium of expression. This is original because it's me. I'm not photocopying off something. I'm not just a mere photocopy machine. And it's a work of authorship because I'm a human author. So this is a copyrighted webinar. This is a copyright statute, 17 U.S.C. 102A, which if you go to the copyright webpage that I told you about at the beginning, you will be able to see 17 U.S.C. 102A. You will see this text, and you will see that there's a list of 8 different kinds of categories of works of authorship. For our purposes here, musical works, including any accompanying words, motion pictures and other audiovisual works, and sound recordings are all considered to be subject matter that's protected by copyright law under 17 U.S.C. 102A. Next slide, please. What is not protected by copyright? This is really important, and I'm just going to go quickly over it because you don't really care what's not protected, but you should know where the boundary is, and the boundaries are kind of fuzzy. The first thing that's not protected is ideas, procedures, processes, systems, methods of operation, concepts, principles, or discovery. This is basically the point that copyright does not protect information. Copyright does not protect ideas. Copyright does not protect information. Copyright does not protect ideas. Copyright protects artistic and literary expression of ideas. Copyright protects the compilation of information, the selection, coordination, and arrangement of information in a unique way. If something is used unlawfully, that's also not subject to copyright. Works of the United States government are not subject to copyright. So you can go ahead and copy anything off of the copyright.gov website that's created by people working for the US government to your heart's content. Now, the Copyright Office, the US government can receive copyright rights from somebody else. So, for example, there was a coin where one side was created by the United States Mint, the other side was created by the winner of an art contest. And there, the US government did own the copyright rights to the portion that was done by the winner of the art contest because there was a transfer of the copyright rights. Another one, and this is for you videographers, sovereign immunity. You cannot sue a state for copyright infringement. This is a case where they're related to, remember I mentioned the Statute of Anne? You may have heard of Queen Anne's Revenge, Blackbeard's ship. What happened was, I think it was North Carolina, where they went and took some videotapes of the salvage of Queen Anne's Revenge, and then this state of North Carolina, I think it was North Carolina, posted the videotape, got sued, and lost because of sovereign immunity. Items that are in the public domain are also not protected by copyright. Public domain means it either lasted more than the copyright term, or it was something that was injected into the public domain prior to March 1, 1989, by, for example, being published without a copyright notice before March 1, 1989. There's a circular. When you go to the copyright.gov website, you'll also see under law and policy, there are a bunch of circulars. The circulars are very useful because they're written for people who are not attorneys. And so Circular 33 points out that names, slogans, titles, short phrases, recipes, blank forms, typeface, and familiar symbols and designs are not subject to copyright protection. Circular 33. Then the biggest exception is probably fair use, where you have something you've done for criticism, comment, news reporting, or teaching. That constitutes fair use. It's not an infringement of copyright. And what the courts do is, on a case-by-case basis, they weigh the four factors of the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. Some of you may have heard that Google and Oracle had a big copyright infringement lawsuit that was just determined by the US Supreme Court about 2 months ago. And the 11,500 lines of code that were copied verbatim by Google for the Android operating system, that was found to be a fair use. So anyway, fair use is a very complex analysis. It's done item on a case-by-case basis. And then the last bullet point is just mentioning that importation of copyright rights, well, is mentioning what we call the first sale doctrine, when you have a particular copy, you're allowed to sell the copy and dispose of that copy by itself. You don't have any violation of copyright laws if someone sells a copy. This is something that you are all familiar with and the reason for it, but you don't know it. When you get some software, you know that you thought you bought software. You did not buy the software. You bought a license for the software. And that's because of this particular provision. Because if you bought a book, you'd be allowed to burn the book. You own the book. That's why software is usually distributed in terms of computer readable object code, a string of zeros and ones. And so in order to figure out how the software works, you normally want to take it apart. Well, that's why you have software licensing, because the license says somewhere in it, you shall not reverse engineer, disassemble, or decompile this software to figure out how it works. And that's why most software is licensed instead of sold. Next slide, please. What rights are granted by copyright? This is very important because this is the heart of copyright. The exclusive rights to do and to authorize any of the following: reproduce in copies or phonorecords, prepare derivative works, distribute copies or phonorecords, perform the copyrighted work publicly. You'll see, though, perform the copyright work publicly, that's item 4. In the case of literary, musical, dramatic, and choreographic works, pantomimes, and motion pictures, and other audiovisual works, there's one kind of work that's missing there: sound recordings. I'll get to that later on. And then you have the display of copyrighted work publicly. That's an exclusive right. And then in the case of sound recordings in 6, to perform the copyrighted work publicly, but only by means of a digital audio transmission. And that was added relatively recently. So I'll get to that further when we discuss the difference between sound recordings and musical works. And then you have a definition in 17 USC 101, which talks about what it means to perform a work publicly. Publicly means to transmit or otherwise communicate. Well, first is to perform a pub or display it at a place open to the public, or any place a substantial number of persons is gathered. So that's what it means publicly. Everyone knows about that. But transmission of the performance is also some public performance. And so you may have heard about watch parties during the pandemic lockdown. Well, I wrote an article indicating that, you know what, pandemic watch parties are probably public performances that are not licensed. So notwithstanding that some browsers allowed you to be able to do that, those probably constitute an unlicensed public performance. And then the last thing is importation. You can stop the importation of infringing products. And there was a first US Supreme Court case in 2013 relating to this. Next slide, please. Oh, by the way, copies of these slides are going to be sent to everybody. So you don't have to spend your time trying to write down everything. Copies of these slides will be sent to everybody, so you don't have to worry about that. You can just pay attention to what's on the slide itself. Most important question for everybody to think about, and this is a critically important question in any kind of legal proceeding, is who owns the copyright rights? So the initial ownership is set by federal statute. Initial ownership, copyright in a work vests initially in the author or authors. Okay, who's the author or authors? Section B says, in the case of a work made for hire, the employer or other person for whom the work was prepared is considered the author. So you know that the author or authors, and then you have a work made for hire. So what I have to point out is that author is a living, breathing, natural person. And a work made for hire is somebody for whom the work was prepared. We'll get to the definition of work for hire very shortly, but this is critically important for all of you to know. I don't care what you're dealing with. This is one of the most critical things you need to understand. Then the third bullet point is in the Ninth Circuit, there's a case relating to the movie about Malcolm X. And the question is, what constitutes enough contribution to be co-authorship? The United States has multiple circuits of states. So we're in the Ninth Circuit, which includes California, Oregon, and several Western states. And so each part of the country is subject to certain circuit courts. And then those circuit courts of appeal, the only court above them is the US Supreme Court. So you have a trial court level in the federal courts. And those federal courts then have these appeal circuit courts. The Ninth Circuit, which is ours, there is this case, and it said that in order to be a co-author, to have enough authorship to be co-author, you have to meet these three requirements. You have to have, well, four. You have to have had independently copyrightable contribution. That means it's got to be enough creativity to be independently copyrightable. You have to be superintending the work by exercising control. You have to have objective manifestations of shared intent to be co-authors. That means you actually say someone is a co-author. That's an objective manifestation of a shared intent to be co-author. And then the audience appeal has to turn on both contributions of all the co-authors' contributions, and the share of each in success cannot be appraised. You can't separate it out one or the other. So, for example, one of my favorite musicals is West Side Story. That was Jerome Robbins' choreography, Leonard Bernstein for the music, and Stephen Sondheim for the lyrics. They were co-authors. They were all supervising. They each had independently copyrightable contribution. They all superintended the work by exercising control. They all listed themselves as co-authors, and the audience appeal turns on all their contributions. You can't separate it out, whether it's the music or the lyrics or the choreography. Next slide, please. What's a work made for hire? This is critically important for all of you, because remember, if it's not a work made for hire, it's the living, breathing person who's the copyright owner. There are two ways in which you can be a work made for hire. One is you're a work prepared by an employee within the scope of employment. That means if you're sitting at a desk and you're being paid a salary and you get a W-2 at the end of the year, then you are probably an employee. And if it's within the scope of your employment, then your employer owns the copyright rights. The second prong to become a copyright work made for hire is a work specially ordered or commissioned for use as, and there are 9 different kinds of works. For this particular audience, the major one is number 2, as a part of a motion picture or other audiovisual work. And then only if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. So what you have here is a two-pronged definition. One, an employee within the scope of his or her employment, or two, you have to be one of these 9 categories of work, and there has to be a written instrument signed by them that the work shall be considered a work made for hire. If you meet one of these two prongs, then it's a work made for hire, and the employer, or the person for whom the work was prepared, the ordered or commissioned person, the ordering or commissioning party, that person owns the copyright right automatically. That's critically important for you because small companies try not to have employees. They try to have independent contractors. Well, if you look at the very bottom of the slide, there was a U.S. Supreme Court case on this. Independent contractors are not employees. They don't qualify under the first prong. Repeat, independent contractors are not employees. If you are going to have an independent contractor, they have to meet what's called the common law agency test. The way I phrase it is this. If someone's working for you as an independent contractor and they run over somebody in a car, are you responsible? If you're controlling them closely enough that you're responsible, then you meet that test, and then they're an employee of yours, and therefore you own the copyright rights that they have. But most of the time, you won't meet that standard. For example, you may hire an independent videographer or an independent sound recording engineer. Then you're probably not going to meet that standard, in which case you can't rely on the first prong. You have to look at the second prong. And you look at the second prong and, oh, no sound recordings, no musical works. But part of a motion picture. So only these 9 categories are eligible. Only these 9 categories are eligible to be converted to a work made for hire by a written instrument. The other thing is the second to last paragraph, which is really, really important for those of us in the Ninth Circuit. A work for hire agreement cannot apply to works that are already in existence. A work for hire agreement cannot apply to works that are already in existence. You've got to sign the agreement before the work comes into existence. I have been preaching this way for years and years and years, but I always see these agreements drafted by attorneys who don't understand this. And yet I'm pretty sure that if you go in front of a federal judge and you make these arguments based on these precedents, that my view will prevail. In fact, I'm certain of it. So for that reason, this is something you need to be aware of, because if you're not aware of this and some lawyer tells you, oh, well, we'll make it into work made for hire because it was already done, and it's not going to work. So you guys need to know this because you are spending all your blood, sweat, and tears in putting together creative works. And this is only one slide for you to think about and understand. Next slide, please. How do you transfer copyright rights? This is critically important. What I tell people is when you're trying to figure out who owns the copyright rights, figure out where the copyright starts and follow the paper trail. Figure out where the copyright right starts and follow the paper trail. It starts with whoever the author is and follow the paper trail. A transfer of copyright ownership is either an exclusive license, an exclusive license, a conveyance, or of any of the exclusive rights comprising the copyright. Remember I said the right to make copies, the right to distribute copies, a couple of slides ago? Those are the exclusive rights, but not including a non-exclusive license. So a transfer of copyright ownership is a transfer of any portion of those exclusive rights and also an exclusive license, but does not include a non-exclusive license. That's what a transfer is. Then you see the next bullet point. A transfer is not valid unless it's in writing, signed by the owner or the owner's agent. It has to be in writing. Copyright rights cannot be transferred orally. I cannot transfer the copyright rights to this video to somebody else orally. You can record the copyright transfers in the Copyright Office. But one thing you need to be aware of, and I mentioned this earlier, is the last bullet point. Transfer of ownership of any material object, including the copy or phono record in which the work was first fixed. In other words, you created and you write a book. The very first copy of that book, the original, that's the copy in which it was first fixed. A transfer of that material object does not of itself convey any rights in the copyrighted work. And it stands to reason. You go to a bookstore, you buy a book, you don't get the copyright rights. Next slide, please. Next slide, please. And okay, this is something that you don't need to read. I just put it up here so that you would be aware of the fact that transfers and licenses of copyright can be terminated 35 years from now. Did we skip a slide? Go back one slide, please, to slide 9. There we go. How long does copyright last? Life of the author plus 70 years. That's how it is for works created after January 1, 1978. Anything beforehand, hire a lawyer with gray hair because it's a complicated situation. For joint works, life of the last surviving author is 70 years. So again, 70 years plus life. And then anonymous works, pseudonymous works, and works made for hire. These are works where you don't have a measuring lifetime. And it's 95 years from a first publication or 120 years from the year of creation, whichever expires first. This is how long copyright lasts, a long time. Next slide, please. This is really, really important for you guys to be aware of because there's a time bomb. There's a time bomb in the vaults of all the record companies and the vaults of all the film companies. Because under this particular provision, 35 years after you transfer copyright rights, the owner of the original owner of the copyright rights, the author, can get the copyright rights back. If the author's alive, it's just the author can go ahead and get the copyright rights back. If the author's dead, the widow plus one of the children, for example, can get the copyright rights back. So if you have music, I personally think that the music in the 1970s was the best music. That's all subject to this kind of, from 1978 on, is subject to this kind of termination of transfers, which means that the heirs, the widows and the orphans, can go ahead, grab those very, very famous and very valuable music recordings, say, oh, I'm terminating the copyright rights, the transfers and the license. I got the copyright rights back. I'm going to relicense them out at the price that they should have been paid for, or that you should have paid. You need to give between 2 and 10 years advance notice, but there's a 5-year window between 35 and 40 years. So this is stuff that you need to be aware of. Next slide, please. Infringement is anyone who violates the exclusive rights. I told you about those exclusive rights, or who imports phono records, and then you violate the copyright rights. You're subject to copyright infringement. When you're dealing with copyright infringement, there are basically 2 issues. Access. Was there someone who had access to the copyrighted work? If the infringer had no access, then there could not be copying, and therefore no copyright infringement. The next thing is substantial similarity. You've got to prove there's a substantial similarity in the copyrightable subject matter, the expression of the ideas, as I mentioned before. Exceeding the scope of a copyright license is also copyright infringement. You license somebody to make 100 copies and they made 300. And then, as I said before, copying artistic or literary expression, because copyright does not protect ideas, only the expression of ideas. Next slide, please. Can a court order a stop to copyright infringement? Absolutely. So courts do that all the time. They can grant temporary and final injunctions. Next slide, please. Can the court order payment of money? Yes, you can. There are 2 kinds of damages or money that you can get. There are 2 kinds of damages you can get, and there's also profits. The first is you can get actual damages, any additional profits. That's one way to get money. The other way to get money is statutory damages, which we'll describe later. So what's really important is that if you have actual damages and additional profits, in establishing profits, all you have to do is present evidence of their gross revenue. You don't have to prove anything that was their cost. You just say, I want their profits. Here's how much they made gross revenue. The infringer has to prove his or her deductible expenses and the elements of profit attributable to factors other than the copyrighted work. So that's when we deal with actual damages and profits. Next slide, please. What the heck are statutory damages? You do not want to be liable for statutory damages. Statutory damages can be between $750 or $30,000 as the court considers just. And the copyright owner has the right to be able to choose that. But if it's willful infringement, the court may increase the award of statutory damage to a sum of not more than $150,000. Remember I said $150,000 in the very first slide? That's where the monetary sum comes from, $150,000 for willful infringement. This is a presentation about copyright law. You've got a copyright attorney providing this presentation. Anyone who copies this and violates my copyright rights is committing willful infringement. On the other hand, if you have no reason to believe your acts constitute an infringement, the court has the discretion to reduce the statutory damage to a sum of not less than $200. The last bullet point is really interesting. You have a Eighth Amendment right to a jury trial on the amount of statutory damages. So if you have a jury, then the jury decides the damages amount. The Feltner case, which is what I'm referring to, is really interesting because they lost in front of a judge. They said, I have a right to a jury trial. They lost, and I think they were liable for like $500 per episode. So they went, the Supreme Court said, you're right. They went back and had a jury trial. I think it was $2,000 an episode. Anyway, they won the battle but lost the war. It was a huge amount that the jury awarded, much more than the original judge had awarded. Next slide, please. Can you get attorney's fees? Yes, you can get attorney's fees. But by the way, you should be aware that there are two big caveats on attorney's fees and statutory damages, which we'll get to later on. Next slide, please. Do you have to pay the other side's attorney's fees if you lose? Yes. This is why this is a different area of law from most other areas of law. In America, under the American rule, usually each side pays its own attorney's fees. Copyright is a potential exception because under the Kurtzsane case, which is the second of those cases I was talking about, you can indeed recover your attorney's fees if you meet the standards. Also, a case that most people are not aware of, if the other side sues you and a reasonable investigation would have disclosed that there was no copyright infringement case, you actually have the right to recover sanctions and get attorney's fees. So you can be forced to pay the other side's attorney's fees if you lose on a copyright infringement case. So that's why you do not want to file a copyright infringement lawsuit unless you're absolutely sure that you have a good case. Next slide, please. Why should you register the copyright rights? Because if you don't, you are not eligible to recover statutory damages or attorney's fees. It says so in the underline, the portion I underline. No award of statutory damages or attorney's fees shall be made for any infringement in an unpublished work commenced before the effective date of its registration. And more importantly, it says no civil action shall be instituted until registration of the copyright claim has been made. So there is an exception with respect to 106AA, which is Visual Artists' Rights Act, but I'm not going to worry about that because this is not a presentation for visual artists, but that's just background information. So basically, you cannot have statutory damages or attorney's fees for infringement prior to the effective date of registration for an unpublished work. Or in the second one, which I forgot to underline, any infringement copyright commenced after first publication and before the effective date of registration. What this means is that if there is an infringement, but you already had the registration in effect at the time of the first infringement, you can recover attorney's fees and statutory damages. But if you don't have a registration when the infringement started, you've lost your right to attorney's fees, you've lost your right to statutory damages. You usually don't want to sue in those circumstances. The other thing is this, case from last year, you must have the actual registration certificate to actually be able to sue. So for that reason, you better have your copyright registration as soon as possible. Next slide, please. How do you register? Until yesterday, I was going to make this a presentation where I could try to give you, tell you how to register your own copyright rights. Yesterday, the US Supreme Court decided they're going to review a case from the Ninth Circuit relating to whether you have to allege fraud before you can have the Copyright Office review a copyright registration. So now I think it's more important. I think you should have an attorney register your copyright rights because the kinds of problems that you can run into with respect to copyright rights, usually people will screw up on naming the right copyright owner. They will screw up on all kinds of other things. I will tell you the things that most people, when they try to register their copyright rights, they screw up on. They don't name the right copyright claimant. The copyright claimant is supposed to be the copyright owner. And if the owner is going to be the author, that's fine. But if you're going to be, if you have a company that you want to be the owner, then you got to make sure either there's a work made for hire or that there's a written transfer of copyright rights. And that's why there's a requirement for a transfer statement. If you're going to go to ECO, the Electronic Copyright Office portal, you need to be aware of that terminology. Copyright claimant is the copyright owner. Transfer statement is the transfer of the copyright rights from whoever was the original author to whoever you want to own it. And then really, really important, you got to understand what the definition of publication is, and we'll get to that later on. It was the case of H&M versus some colors. But anyway, that just happened yesterday. So we're going to have an opinion by the US Supreme Court in about a year with respect to various aspects of copyright registration. The second bullet point points out that if you've got 10 unpublished works, You can do one registration per unit of publication. And so that means everything was done all at one in one bundle. And then you have to select the proper type of work: literary, visual arts, sound recording, performer arts, motion picture, audiovisual work. Usually, if you're dealing with music, you're going to have two kinds of works. You're going to have a sound recording for the actual recording, and the owner of the copyright rights there is probably going to be sound engineer. And then you're going to have the copyright rights to the underlying work. So, for example, I love it when Barbra Streisand sings any of the Broadway songs, but she's not the author of those Broadway songs. However, she was the author of one of my favorite songs called Evergreen. And so she would own the copyright rights for PA, performing arts, working with performing arts, as a composer. And for Evergreen, she can also potentially own copyright rights to the sound recording if she helps engineer it. But all the other ones, she doesn't get any royalties for being a performer, because remember I said sound recordings, you don't get performance royalties. Sound recordings are works that do not include soundtracks. They do not include soundtracks. Motion pictures, they have to impart an impression of motion, and audiovisual works are works that are intrinsically intended to be shown by the use of machines or devices. Next slide, please. What is publication? Distribution of copies or phonorecords. Look at the second and third bullet points. Copies are material objects. Phonorecords are material objects excluding soundtracks. So you have to remember, copies and phonorecords are material objects. So what's publication? Distribution of copies or phonorecords to the public by sale, or by other transfer of ownership, or by rental, lease, or lending. The offering to distribute copies or phonorecords to a group of persons for purposes of further distribution, public performance, or public display constitutes publication. By the way, I did register the copyright rights to this slideshow yesterday, so in case you guys are wondering, yes, I will sue you for copyright infringement, and yes, I will assert and obtain attorney's fees and statutory damages. So don't make unauthorized copies of this. So anyway, it's critically important you understand publication, because if you don't understand publication, you can fill out the copyright application wrongly. For example, I was just reading a case by the Register of Copyright Rights relating to about 30 different fabric designs. And some of them were exclusive fabric designs that were withheld from the showroom. And so because of that, the Copyright Office said, we may not have allowed registration of some of these. That may invalidate the judgments that were done by the court. So that's why it's critically important to know what's published and what is not published. So you look at this definition, stare at this definition, memorize the definition: distribution of copies or phonorecords to the public, or the offering to distribute to a group of persons for purposes of further distribution, public performance, or public display. Better yet, get a copyright attorney. And I can count on the fingers of one hand the people in the state of Hawaii who understand copyright law well enough that I'd have faith that they did the copyright application properly. And one of those people is my partner. Next slide, please. What's copyright notice? See with a circle the word copyright and the year of first publication, and the name of the owner of the copyright in the work. So you've all have seen that. See with a circle or the word copyright, the year of first publication, and then the name of the copyright owner. This is no longer mandatory, but if you have something that was before March 1, 1989, then it requires a copyright notice. If it was published without a copyright notice prior to March 1, 1989, it may have been injected into the public domain. Next slide, please. Copyright notice for phonorecords is P with a circle, year of first publication, name of the owner of copyright, and the sound recording. You should be aware that copyright law has changed very substantially in the last couple of years. Most importantly, there's the Music Modernization Act, which just got passed. I'll mention some of that later on. But pre-1977 phonorecords may possibly be subject to some pre-72 copyright protection now. Next slide, please. Statute of limitations, 3 years. You can't sue more than 3 years after the claim accrued. You can sue for the last 3 years of damages, even decades afterwards. I'm fighting with somebody now whether that means you can only sue for the last 3 years of damages, or whether you sue for within 3 years of the start, but sue for earlier periods. I think that's wrong. I think that the Supreme Court's decision that I've cited there means you can only sue for the last 3 years of damages, but that's something that I'm dealing with right now. Next slide, please. This is something critically important to those of you who are involved with music recordings. Of performing rights societies, there are PPOs, performing public performance organizations, I guess. There's ASCAP, it has members, and it operates under a consent decree because of the antitrust implications. There's BMI, it has members, and it also is operating under a consent decree. Both ASCAP and BMI are operating for the benefit of their members. They're nonprofit organizations, and they're legitimate. And each of them owns almost 50% of the popular repertoire. CSAC is a private for-profit company that says that I think that they are wrong when they say, oh, this artist signed or performed a CSAC song, therefore they're a CSAC artist. Global Music Rights is a relatively new, very new performing rights society. And that's something that's also private and for-profit. Each country has its own performing rights societies, and ASCAP, BMI, and CSAC have relations with those other performing rights societies. That's how you get your royalties for performing performances in future other countries. Other countries, they do give performance rights to the performers. So you do collect royalties. So Barbra Streisand in foreign countries, when you sing a Broadway song, would probably get royalties as the performer on the song in those foreign countries through that performing rights society. Next slide, please. Resources available to musicians and movie makers. Copyright.gov/engage. There are multiple circulars. I can show them here. There are multiple circulars that are at the Copyright Office, which talk about how to register multimedia works, sound recordings, musical compositions. They're all available for download at the copyright.gov website. Very, very important for those of you who are musicians, the MLC.com, the Mechanical License Corporation, or company, I forgot exactly what it was. There's a new mechanical license, about 2 or 3 years old, for streaming and downloading of music. And the point that's really, really important is in January of this year, they started distributing royalties. They are required to keep a database of all the people to whom they're supposed to be paying royalties. So you run, do not walk, you run to themlc.com and you make sure that you are up there so that you can get your share of the mechanical license for streaming and downloading of music. Next slide, please. Are there other kinds of licenses? Yes. Synchronization license, those of you in the motion picture industry, that's the kind of license where it's music and synchronization with pictures, there's a negotiated royalty rate. There's a traditional mechanical license for publicly released music on phonorecords. That's the mechanical license rate that's set by the Copyright Royalty Board. There are grand rights when you're dealing with dramatic musicals or other kinds of dramatical musical works, and that's the dramatic performance of music, and that's at a negotiated royalty rate. And there are the small rights, which are the non-dramatic performance of music from a dramatic musical work. Next slide, please. Are there exclusions? There are certain kinds of exclusions from public performance right, certain face-to-face teaching, certain remote teaching, certain religious services, bars and restaurants less than 3,750 square feet. That violates the World Intellectual Property Organization, but it's still part of our statute. Annual agricultural or horticultural fairs. So you can read these exemptions there in 17 U.S.C. 110. Next slide, please. And we are at the question and answer phase. And I think that we're at the 45 minutes.
That's
so
great.
I was able to pace it properly.
Thank you so much, Martin. Paul, if you can pull the slides off for us, please. And there are actually a couple questions that popped up during the presentation. The first one is, if copyrights only last 35 years, do we have to reapply after that in order to retain ownership?
Well, I don't know who said copyright lasts 35 years. Life of the author plus 70. Prior to January 1, 1978, copyrights lasted for 28 years and a renewal term, which they kept on adding. It's not that copyrights last for 35 years. It's that any transfer or license of copyright rights can be terminated during a 5-year window. If you don't terminate it during that 5-year window, then the author gets the copyright rights back. So that's where the 35 years comes from.
Got it.
What was the question about it with that 35 years?
So the question is, so let's say I have produced a documentary, right? And I apply for a copyright, I receive it. How long is that copyright for? Oh, good.
Life of the author plus 70 years.
Got it. So if I live to be
Unless it's a work for hire, in which case
no. So I produced it myself. I financed it myself. So I live to be 100. That means that the copyright will be good up until 100 for 170 years. If I live to be 100.
Yes.
Perfect.
But it's just that if you sold that or
Right.
licensed it to somebody else, 35 years after the sale of the license, you can get the copyright rights back.
Reverts back. So in other words, if I license a documentary to you, right, after 35 years, I can actually claim, I can request that copyright back,
Right.
which is what you talked about with the music and the
Right.
in the 70s. That's perfect.
Right.
And then the next one is it's around the screenplay. So the question is, for a screenplay, because the story changes with the filming of a project, right? Should the creator get a copyright before and after filming in order to ensure that the changes that have been made after the project has been filmed are protected? Or does that new version of the script become part of the actual the person who either financed or produced and owns the film?
Okay, the screenplay, assuming that it's a script, something like a script,
Yes.
In writing, on text, you would register the copyright rights to that, absolutely. Because you want to make sure before you give it to anyone else that you've got the copyright rights registered. After it's been done, then you'd register the copyright rights to the finished product. And yes, there will be changes. The Copyright Office takes the position that insignificant changes or insubstantial changes don't justify a new copyright registration. But I think between a screenplay and a movie or other audiovisual work, they'll say there's a lot more there and therefore is subject to it and eligible for another copyright registration.
Got it. Perfect.
For about $65 each, it's cheap to do copyrights. The biggest mistake most people make is that they want to register a whole bunch of photographs or a whole bunch of designs all at once.
Right.
And just to save the $65, previously was $35 each design. And
Got
you
it.
can do that, but nowadays they've limited it to only 10 unpublished works per. Previously, it was, you could do hundreds. I used to do hundreds of photographs. You can do 750 photographs at once, but it's only for photographs.
Got it.
These changes, there have been a lot of changes in copyright registration procedures recently.
Got it. So the next one is, if we are hired to illustrate a book from an independent person, would that be a work for hire, or would it still, or would that work still be a copyright that I can apply for?
Well, you better figure out the work. Look at the slide on work for hire and see what the answer is.
Right.
Because first of all, is this before the work was created? Probably, because you're being created. Was there a written agreement? And then when I look at the slide, which is slide 7, I don't know if Paul can put up the slide. Slide 7 shows that there are 9 special categories of work. And one of those, it says supplementary work. And a supplementary work, I did not underline this, but a supplementary work is a work prepared for publication as secondary adjunct for a purpose of illustrating. So that's why it would qualify, because it's supplementary work. So it's eligible to be made into a work made for hire. But if you don't sign an agreement that says it's a work made for hire prior to creation of the work, then it's not a work made for hire, in which case you still retain the ownership rights. If you want to transfer it, you can, but it has to be in writing.
Even if they've exchanged money. So in other words, if okay, perfect. So in other words, if I paid you, Martin, $100 and it said, I want you to draw this, but I did not give you an agreement, a work for hire agreement, you could take the $100 and still own the material.
Yes.
Got it. Perfect. So the next question is, producers planning to use or recite a part of a poem in a film. So should that producer secure the licensing rights to be able to do so?
Yes, absolutely. Otherwise, you end up with a potential lawsuit.
Got it. Perfect. So now let me just make sure that we've answered all of the, okay, so here's the other. For a visual artist, what are the pros and cons of copyrighting several works under one registration?
The con is that if you end up with one or more of those works under that registration being published accidentally. So let's say you have 3 works and one of them has been published and you register the copyright for all 3 as an unpublished collection, you jeopardize the copyright rights for all 3 of them. That is some of the most recent stuff that's been going on. That's typically how people are attacking copyright registrations now. And I mentioned the case with respect to the fabric designs where someone did exactly that. They had several fabric designs, works of the visual arts, and several of them were made available exclusively to certain people, and others were not. And the ones that were not made exclusive were offered to the general public. What that meant was that the copyright application covered a lot of works, some of which were published and some of which were not. And the Copyright Office would not have registered the copyright rights. So that's why you've got to be really, really careful about publication, because you've got to be sure that you are actually published. So that is why when I registered the copyright rights for this slideshow and the copyright rights for next week's slideshow, I did them as two separate copyright registrations, because it was an offering to a person or maybe a group of people for purposes of further distribution. And maybe they were published, and therefore I should not have done it as two in an unpublished collection. So that's why when you want to be safe, you want to be absolutely certain there's no publication here, because if you put a bunch of works together, you may jeopardize all of them by trying to save about $65.
Got it. So one of the things, I want to ground this in some real world applications. So I've produced a movie, right? I self-funded it. I purchased the screenplay. I paid the actors, the directors, everyone. Everyone was a work for hire. I own the copyright. I've registered, the film, and have a copyright on the film. A distributor approaches me. Can you explain the difference between me licensing the film versus me assigning the copyright to the distributor?
Licensing means that you still own the copyright rights and you're just renting it to them. License means rental. Assignment means I'm giving it away. I don't have any rights to it. Deed. So that's why if the Beatles were all alive now, they still could not perform a lot of their music because their music was held by Apple Records. And Apple Records was at one point held by Michael Jackson, but not the Beatles. And so they could not even perform their own music because they didn't own the copyright rights anymore, even though they were the authors. So that's why there's a huge difference between licensing and assigning. And basically the same difference as between a deed and a lease.
Perfect. So here's another question. So I'm a playwright. I've written a play, right? Can I license my play to, say, a television company in Japan to produce a TV movie? Can I license the same play to a company in England to produce a movie? What can I split my rights to that extent and continue? Yes. So in other words,
you can.
Perfect.
But the real problem you have is, are you giving anyone exclusivity? So if you're saying, I'm going to give you, the Japanese company, the exclusive right to make a movie worldwide, then you can't go ahead and go to the UK. Now, if you give, however, to the Japanese the exclusive right to make a movie in Japanese, maybe there's going to be different because you're not infringing on that exclusive right or violating the exclusivity by licensing someone in the UK that's not in Japanese.
Got it. So in other words, the important part there is to make sure that you are very specific in assigning the rights to a very specific either platform and location, geographical location, potentially even language, right?
Right.
I could potentially license the English-speaking language rights. I could license the French-speaking language rights, and so on and so forth, but all with the intention that at the end of the day, I own the underlying material, and at some point, those licenses will revert back to me.
They won't revert. You have to actually give between 2 and 10 years of prior notice and do it within the 5-year period, effective within the 5-year period, starting 35 years from the date of the assignment or license.
Perfect. So one other question, by the way, I'm just checking to see if there are any other additional questions from our guests here. So I option a book. Right. So there's an underlying author who has written a book, and I plan to option the book for a certain amount of time. And I, as a writer, plan to adapt the book as a screenplay. Right. So in order to, so my question to you is, can I copyright the adaptation under my name, or is that something that would be also privy to the owner of the copyright of the book?
Whenever you create a derivative work, there are going to be 2 copyright rights. One is the copyright right in the underlying work, which does not change. And the next is the copyright rights in the derivative, the changes that you made, the additions that you made. The 2 copyright rights will coexist. And so what you need to do is when you're doing the copyright application, you must state what the pre-existing material is, and you must describe it. And so what you would do is you would say, I'm registering the copyright rights to a screenplay. This would probably be under Form TX as a work, as a literary work. And then in the pre-existing material, you'd have to list an exclusion, and the exclusion of pre-existing material would be stating that it's a book by whatever, list that as the pre-existing work. And then what you would do is you say is what your contribution was is additional text, for example. You need to be very careful and do this correctly, because that seems to be how some people are trying to knock out copyright registrations by saying you failed to disclose that there was a pre-existing work. So you need to be as clear as you can. It used to be the copyrights, nobody cared that much about how accurate you were in the copyright registration. But over the last 20 years or so, I've seen more and more of a trend, people looking at them more and more like patent applications and trademark applications, and looking at the minutiae of how it was that the processing was done in the Copyright Office. I'm not saying that's good or bad, but I am saying because of the complexities and how many ways people can screw up on it, it would be best if you had an attorney do it. I have never seen someone who is not a practicing copyright attorney do a copyright registration correctly. Never. And when it comes time to filing a lawsuit in court, you need it to be done correctly. If you want to just do it yourself on your own, I've tried to give you as much help as I could. That is one of the reasons I gave you the statutory text. So you can go back to the Copyright Office's website, read the statutory text, look at the circulars, see whether your understanding is correct. And if you want to, you can try to open your own account at Electronic Copyright Office, file your own copyright application. I've given you the information. This webinar is being recorded, so you can look at the slides. I'm not saying you'll do it right, but at least you'll have a better chance of doing it right than most attorneys, and definitely most laymen.
Awesome. So before we complete, I also want to say to those watching and those who plan to consume the video later, that the Copyright Office has also a very robust YouTube channel with a lot of videos on how-tos and explaining all those things. So on top of the information that Martin shared with us tonight on the actual copyright.gov site, we also invite all of you to visit the YouTube page, because there are a lot of how-to videos that the Copyright Office has recently produced and posted on that site. Martin, thank you so much for this awesome presentation. I really appreciate it. We really appreciate it. As a reminder, this video will be posted on our Facebook page, as well as those who participated in tonight's webinar will receive a copy of the slides. So one of the things that I wanted to mention is Martin will be back next week at the same time to talk about the topic of trademarks. It's scheduled for Wednesday, June 9th at 6 p.m. Hawaii. Please visit creativelab.hawaii.gov for registration information. On behalf of Martin Shaw and the State of Hawaii DBET Creative Industries Division, mahalo and have a great evening. Thank you.
Thank you.